Imagine this. All across America, more than half the country is now telling the Supreme Court that lower courts are mocking the Second Amendment by twisting the rulings in Heller and Bruen just to keep bans on magazines in place. This is not some obscure legal debate. It affects millions of ordinary people who own firearms for self-defense, sport, and hunting. At the very center of this fight are the magazines that hold more than 10 rounds, items that are not rare, not exotic, and not some military luxury. They are standard. Yet in Washington state and in 13 other states, these very same magazines have been banned, and recently the Washington Supreme Court upheld that ban. That decision may end up being the spark that drives one of the biggest Second Amendment cases since Bruen. Think about it for a moment. At least half of American gun owners, law-abiding citizens, possess what politicians like to call large-capacity magazines. In truth, they are nothing more than the standard magazines that come with the most popular firearms. A Glock 17 ships with a 17-round magazine. An AR-15 typically uses a 30-round magazine. These are not oddities, they are the default. Surveys show that nearly half of gun owners have magazines that hold more than 10 rounds, and estimates suggest there are over 500 million such magazines in circulation. When something is owned by hundreds of millions of people, it is not unusual, it is mainstream. And yet Washington insists on treating these items as though they were fringe contraband. The state's highest court justified its decision by claiming that magazines are not arms protected by the Second Amendment. Even if they were, the court argued they are not commonly used for self-defense. That reasoning is a contradiction in itself. The court admitted there are tens of millions of these magazines in circulation, then turned around and said they are not protected. That is legal gymnastics at its worst, and it has fueled outrage across the country. It is also why 26 states have joined together to file an amicus brief urging the United States Supreme Court to finally step in and stop this nonsense. To understand how serious this is, remember what the Supreme Court said in the 2022 Bruen decision. The court made it crystal clear that governments cannot invent new balancing tests to restrict the right to bear arms. Instead, they must show that any modern gun regulation is consistent with the historical tradition of firearm regulation in America. This is known as the Bruen test. In plain language, if a government wants to ban or restrict something today, it has to prove that similar restrictions existed in the past. If no such historical example exists, then the modern restriction fails. Washington, like other states pushing these bans, has not been able to provide a relevant example. So their courts simply make up new requirements like demanding that an item be commonly used in self-defense specifically. The Constitution does not say that, and neither did the Supreme Court. This is the trick that anti-gun jurisdictions are pulling. They try to narrow the definition of what counts as protected arms. But the Second Amendment does not limit protection to firearms that are only useful in a self-defense scenario. It protects arms that are commonly possessed by law-abiding citizens for lawful purposes, period. Those lawful purposes include self-defense, but they also include hunting, training, and sport. Magazines are essential to the basic function of almost every modern repeating firearm. Pretending they are not is like pretending the First Amendment protects newspapers, but not the ink and paper. A pistol without a magazine is like a car without a gas tank. You can sit in it, maybe coast down a hill, but it is not going anywhere. Without magazines, the firearm is reduced to a single-shot tool stripped of its intended function. Ordinary Americans know this instinctively. They see that these magazines are not some luxury accessory. They are simply part of the firearm they bought legally and responsibly. When nearly half of all gun owners possess them, there is no honest way to say they are unusual. Yet in Washington, Illinois, California, and other states, law-abiding citizens are being told they are criminals for owning what millions of their fellow Americans own without question. This patchwork of bans does not just confuse people, it undermines the uniform protection of constitutional rights. Unless the Supreme Court steps in, the Second Amendment will mean one thing in Texas and something entirely different in Washington. That cannot stand, and that is why this case matters so deeply. The case now moving forward is officially called Gator's Custom Guns versus Washington. The Washington Supreme Court upheld the state's ban on magazines holding more than 10 rounds, and that ruling has now been appealed to the United States Supreme Court. What makes this moment historic is that 26 states have joined forces to file a powerful amicus brief demanding that the Supreme Court take the case and reverse Washington's decision. Montana and Idaho led the charge, and they were joined by states like Alabama, Alaska, Arkansas, Florida, Georgia, Iowa, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, and Wyoming. Even the Arizona state legislature stepped in. Together, they argued that magazines over 10 rounds are an essential part of the firearms commonly owned by Americans, and that banning them is a direct violation of constitutional rights. The message from these states is unmistakable. They are not simply defending Washington gun owners. They are warning that unless the Supreme Court steps in, courts in anti-gun jurisdictions will continue to water down the Second Amendment until it means nothing. These states argue that only the Supreme Court can end this pattern of defiance. Lower courts are inventing new standards, twisting precedent, and ignoring what the Constitution actually says. The states point out that when nearly half of all gun owners possess hundreds of millions of these magazines, no judge should be able to call them unusual or unnecessary. Think about how far some courts have already gone. The Fourth Circuit declared that AR-15 rifles are not really arms at all. The Seventh Circuit claimed that AR-15s are essentially the same as military M16s and therefore can be banned. The First Circuit insisted that popularity does not matter, only usefulness for self-defense. Every one of these rulings contradicts what the Supreme Court already established in Heller and Bruen. In Heller, the court made clear that weapons in common use by law-abiding citizens for lawful purposes cannot be banned. In Bruen, the court demanded that governments justify gun laws with historical tradition, not judicial creativity. Yet these lower courts are pushing their own agendas, and ordinary Americans are the ones paying the price. The states supporting this brief also remind the Supreme Court of McDonald v. Chicago. The 2010 case that confirmed the Second Amendment applies not just to the federal government, but also to the states. That principle, known as the incorporation doctrine, means state governments cannot ignore the Bill of Rights. Washington's ruling runs directly against that, and the coalition of states is asking the court to enforce its own precedent. Their argument is simple: magazines are arms, they are in common use, and there is no historical tradition of banning them. That should be the end of the discussion. At the heart of all this is a straightforward concept often called the common use doctrine. If an arm, or an essential component of an arm, is commonly possessed by law-abiding citizens for lawful purposes, then it is protected. That is why the court in Caetano v. Massachusetts unanimously ruled that stun guns were protected, even though only about 200,000 people own them. If that level of ownership counted as common, then hundreds of millions of magazines absolutely qualify. The lower courts, pretending otherwise, are not applying the law, they are rewriting it. Americans do not need legal training to see the problem. They know a firearm without a magazine is crippled. They know the Second Amendment was not written to allow each state to whittle away rights as it pleases. They see that politicians in some states are using creative judges to do what legislatures cannot pass in the light of day. And they understand that without a firm ruling from the Supreme Court, the Second Amendment will continue to be chipped away, case by case, state by state, until nothing is left. This is why so many eyes are on the court right now. The coalition of states has made the stakes clear. Either the Supreme Court enforces its own precedents and restores consistency across the country, or it allows a patchwork of hostile rulings to stand. If the court refuses to take the case, millions of Americans will live under unconstitutional bans while their fellow citizens across state lines enjoy full rights. That is not how the Bill of Rights was designed, and that is not how freedom survives. Washington tried to defend its ban by pointing to historical examples, but the comparisons collapse under even the slightest scrutiny. They cited trap gun laws, which were never about bearable arms, but about outlawing dangerous booby traps. They mentioned gunpowder storage laws, which were fire safety measures, not restrictions on carrying arms. They even brought up Bowie knife regulations, but those came long after the Second Amendment was adopted and did not ban possession outright. Most of those laws have since been overturned or abandoned. None of them come close to justifying a modern ban on the very components that make firearms function. The attempt to tie these unrelated historical curiosities to today's magazine bans shows how weak the state's case really is. Meanwhile, this fight is not limited to Washington. Courts in Illinois, Rhode Island, Massachusetts, and California have all upheld similar bans. Each of these states claims they are simply regulating dangerous items, but what they are really doing is redefining constitutional rights to suit political agendas. The result is a patchwork of laws where the rights of millions of Americans depend entirely on state lines. A citizen in Texas can legally own the exact same magazine that would make him a criminal in California. That is not equal protection under the Constitution. That is a divided nation where basic rights vanish when you cross into the wrong jurisdiction. The Supreme Court has already given us a clear standard in past cases, in Caetano Vitis. Massachusetts, the court unanimously struck down a state court ruling that claimed stun guns were not protected. At the time, only around 200,000 people owned stun guns, yet the court still ruled that they qualified as arms under the Second Amendment. If a few 100,000 devices were enough to be considered common, then the hundreds of millions of magazines in circulation today must certainly qualify. To argue otherwise is to ignore not only the plain meaning of the Constitution, but also the clear direction of Supreme Court precedent. Ordinary Americans understand the absurdity here. They know that magazines are not optional extras. They are the fuel tank of modern firearms. Without them, the tool is crippled. They also see the danger of allowing activist judges to twist legal definitions in order to reach the political outcome they prefer. If these rulings stand, the Second Amendment will become a hollow promise honored in some states and denied in others. That is not how rights are supposed to work. The Bill of Rights was written to protect the people against government overreach, not to give state courts the authority to erase fundamental freedoms whenever they choose. The choice now rests with the United States Supreme Court. 26 states have put their weight behind this challenge, making it clear that the issue cannot be ignored. The question is whether the court will finally settle the magazine ban fight once and for all, or whether it will allow hostile jurisdictions to keep pushing the limits of defiance. If the court takes the case and rules as its own precedents require, it will restore uniformity and protect the rights of millions. If it refuses, the patchwork will only grow worse, and Americans will continue to see their freedoms chipped away depending on where they live. This moment is about more than magazines. It is about whether the Second Amendment still means what it says. It is about whether the Supreme Court will enforce its own rulings or let lower courts run wild. Most of all, it is about whether the rights guaranteed in the Constitution will be defended equally for every American. The nation is watching, and history will judge what happens next. Alehingay by Baune HTTPS OPBB Article Gator's Gun Store Us Supreme Court Review Chupkam Chutitang